Have you ever wondered what makes a contract unenforceable? In law, we refer to them as vitiating factors, which are factors that will render a contract void or voidable. Today, we are focusing on the doctrine of undue influence, in which we will compare and contrast its application in both the jurisdiction of English law and Malaysian law.
The doctrine of undue influence, which is an equitable doctrine, is brought upon to protect individuals for claims which involve the elements of oppression, betrayal, deception, and pressure, which is the abuse of interpersonal power in consensual contracts.
It is provided in Section 16 of the Contract Act 1950, and the provisions are quite similar to the common law approach of this doctrine.
The resolution of a claim in undue influence actually depends on the meticulous examination of facts, as courts have been known to interpret this doctrine flexibly.
Imagine if someone threatens to stab your cat unless you do their contract homework for them. We call that actual undue influence. The approach of actual undue influence is a defendant-sided approach which places a fetter on the conscience of the contractual parties to prevent what some commentators call a wicked exploitation. The case of Royal Bank of Scotland against Attridge sets out the elements required to establish a case of actual undue influence. Firstly, the act committed by the dominant party has to be an equitable wrong. Secondly, it must be unconscionable for the dominant party to assert his legal rights against the other. And thirdly, there must be some express conduct by the dominant party which overbears the other party's will and consent in regards to the entry to the transaction. Unlike other types of undue influence, in the case of actual undue influence, the burden of proof lies entirely upon the person who is alleging the act of undue influence, which we call the claimant. However, in this approach, it doesn't depend upon the relationship and history between the contractual parties. This means that when using this approach, it is irrelevant whether there exists any pre-existing relationship or any previous instances of influence between the parties. Also, it is not needed for the claimant to show that the transaction was in fact causing or have caused any disadvantage to them. This means that the claimant need only prove that there exists an act of actual undue influence that has been asserted upon them. With that being said, if it is proven that there is indeed a case of actual undue influence, the contract entered into would be voidable at the option of the claimant. In the case of Williams against Bailey, a son forged his father's signature on promissory notes and gave them to the bank. When the bank found out, they told the father that unless the father would take responsibility of the son's action, they would criminally prosecute the son. Therefore, the father entered into an agreement with the bank in consideration of return of the promissory notes. Later, when the father sought cancellation of the agreement, it was held by Lord Westbury that the father wasn't given the freedom and power of deliberation that is necessary to make a contract valid. That is, because this bank has threatened to criminally prosecute the father's son, actual undue influence was asserted upon the father, and therefore the contract was voidable at option of the father. In short, to establish an act of actual undue influence, the claimant must show that the act was an express conduct regarded as an equitable wrong, unconscionably done by the dominant party, overbearing the claimant's will and consent to enter into the contract. Note that it is irrelevant whether there was a pre-existing relationship between the parties or whether that the transaction has caused a disadvantage towards the claimant.
Now we will continue with presumed undue influence. First of all, the distinction between actual and undue influence is actual undue influence is said to be proven by affirmative evidence such as overt act of coercion and illegitimate pressure, whereas presumed undue influence is concerned with more subtle forms of unacceptable conduct which cannot be proven by objective evidence but are presumed to exist because of the relationship between the two parties. In this case, the House of Lords has introduced a note of caution which in effect to discourage too much reliance on the presumption of undue influence. It is hard to determine the relationship between influence and undue influence. It is always based on the facts of the case to determine whether there is a presumption of undue influence. Next will be the element of constituting presumed undue influence. There are three. First, proof of trust and confident relationship. Second, something that calls for an explanation about the transaction. Third, whether the presumption is rebuttable. Under the trust and confident relationship, there has two categories, which are Class 2A refer to a special relationship as a matter of law raise a presumption of undue influence that has been exercised, such as solicitor and client, doctor and patient, beneficiary and trustee. Another is Class 2B, refer to de facto existence of relationship. It means that if the claimant prove the existence of such relationship under which the claimant generally repose trust and confidence in the wrongdoer, it will raise a presumption of undue influence. Therefore, in Class 2B case, where in the absence of the evidence that disproves undue influence, the claimant will succeed in setting aside the invent transaction married by proof of trust and confidence relationship without having to prove the wrongdoer had exerted actual undue influence or otherwise abused such trust and confidence in relation to the particular transaction impugned. Under Malaysian perspective, Section 16, Subsection 2 of Contract Act 1950 is referred to presumed undue influence in common law since it is analogous to common law. According to this provision, three categories of relationship are defined. First, the person with real and apparent authority over another, then there's fiduciary relationship, and those who are mental incapable of forming contracts. Moreover, the requirement to fulfill this provision is much more similar to the element in order to establish presumed undue influence in common law. However, if the claimant can rely Section 16, Subsection 2 to prove that influence, he still has to go on to prove the wrongdoer has abused such position to obtain unfair advantage. The subsequent part will be presented by my other group members. Thank you.
Relationship between parties are crucial in determining to what extent one can influence another to enter into a contract. My job is to break down the relationships in both jurisdictions. Section 16, Subsection 2 of the Contracts Act classifies relationships based on dominance, fiduciary, and mental capacity. Any of these will raise a rebuttable presumption of undue influence. As for common law, there are Class 1 and Class 2A-2B relationships. We would like to focus on the relationships of a husband and wife, which is very controversial in this doctrine.
I wonder why. A wife easily influences the husband, right?
This position was later on overruled by the courts in the case of Royal Bank of Scotland, which is decided based on public policy reasons. Why? Because the courts want to assume a happy and amicable relationship between husband and wife. A commentary on a current case reveals that cases involving spouses being guarantors should not be based on undue influence but instead consumer credit law. Interestingly, there is no present Malaysian case that follows the position in Edrich provided under Hillsbury laws of Malaysia. The unpredictable stance of this specific relationship is criticized by Justice Gopal Sriram. Hence, it is still difficult to establish a presumption of undue influence in marital relationships. The court should start making changes to the way they view marital relationships. It is already 2017, and it's about time we take into account of the nasty turn of relationships. Spouses need protection from each other too. Next, we have fiduciary relationships. English law has no express mention for the term fiduciary, although it is similar to the relationship of trustee-beneficiary or even a solicitor-client relationship. Finally, mental incapacity. A presumption arises in a Malaysian context when a person's mental capacity has been afflicted by illness or something else. As for English law, whether or not the doctrine extends to mental incapacity is unknown. Perhaps the principles under Section 3 of the Mental Capacity Act 2005 will apply under such circumstances. Since undue influence is a flexible doctrine and is based on equity, the law should develop to take into account of various other relationships and have clearer classifications of the relationships, and further expansion of it is needed too.
A relationship of influence and a transaction which calls for an explanation are the two elements that are needed to raise the presumption of undue influence. Once this has been proven, the burden of proof then shifts to the defendant to disprove the presumption of undue influence. And the greater the disadvantage to the victimized party, a more cogent explanation will be needed by the courts from the defendant to disprove the presumption of undue influence. This requirement was then overruled in this case, in which Lord Brown Wilkinson said that it was only applicable to cases of presumed undue influence, the requirement of a transaction which calls for an explanation or manifestly disadvantageous transaction is not needed in cases of actual undue influence. In the landmark case of Etheridge, Lord Nichols prefers the approach of looking at a transaction which calls for an explanation upon looking at the facts of the case instead of looking at transactions which are manifestly disadvantageous in irrefutably proving presumed undue influence. The House of Lords have defined the pertinent principles that are looked into in the doctrine of undue influence in the cases of Etheridge and Pitt, and this has removed the uncertainties in the doctrine of undue influence in which courts used to have a discretion as to whether they prioritize manifestly disadvantageous transactions or just the nature of relationship between parties. In the Malaysian context, an unconscionable conduct is an element needed to prove the doctrine of undue influence, as required in Section 16, Subsection 3 of the Contracts Act 1950. The Malaysian courts have not clearly defined the term unconscionable, and hence facts of the case self-explanatorily aid the courts in determining what an unconscionable conduct is. Based on case laws, for a bargain to be unconscionable, 3 criteria must exist: a transactional imbalance, a relational imbalance, and impropriety. To draw a parallel of this to the common law, the mere fact that these criteria exist would call for an explanation by the defendant. Hence, the party in a dominant position would have to rebut this presumption, or in other words, is called by the courts for an explanation. Although different terms are used, undue influence is still an equitable doctrine that prevents courts from enforcing unfair contracts and provides reliefs to affected individuals. Next, we'll move on to a segment by Dave on how well do you know your contracts.
Good evening and welcome to How Well Do You Know Your Contracts with Mahadev Singh. In the last episode, we learned about the claimant needing to prove that there was an existence of a relationship and also question the nature of transaction. Today, we will examine the presumption that needs to be rebutted by the defendant. According to Evan McKendrick, it is the defendant's attempt to rebut the interference of undue influence that has arisen from the proof by the claimant. The defendant will have to prove 3 things. The first, the defendant needs to show us that the claimant had received independent advice. According to Triatel in the law of contract, not only must that person be able to get independent advice, the person providing this advice must be competent and have knowledge on the nature of the transaction that is taking place. However, understand that the follow-up to this is that the claimant must use the advice and apply it with free will and independence into the transaction. This is where we move into the words put in the book called Executors, Administrators and Probate by Williams and Mortimer, that the claimant, upon receiving this advice, must be able to exercise accurate judgment that is free from any form of influence. Before we compare and contrast the differences and similarities between the common law and Malaysian law, let's look at the burden of proof that is set on the defendant in Malaysian law. Under Section 16, Subsection 3A of the Contracts Act 1950, the burden of proving the contract that was not induced lies upon the person in a position to dominate the will of the other. Having established the burden of proof that needs to be shown by the defendant in Malaysian law and the presumption that needs to be rebutted in English law, let's look at 2 cases that apply separately in each jurisdiction but focuses on a common principle. In Malaysia, we have the case of Inche Noria against Shaikh, and in common law, we have Alcard against Skinner. The common thing between both these cases is that where independent advice is provided, the independent advice must come after the nature of the transaction is fully explained to the individual by an independent third party. Only then can a decision be made to consent to that transaction. Otherwise, you may have a situation like in Alcard against Skinner where the claimant was overly reliant on the defendant for the person's advice. In conclusion, what we can deduce for the defendant's point of view in both Malaysian law and common law is that number 1, you need to have the claimant needs to be given independent advice from a third party. that the advice must include the explanation of the nature of transaction, and only then can the claimant make a decision to consent to the transaction. If the defendant can show these three things, then the presumption is rebutted in common law and the burden of proof is fulfilled in Malaysian law. That's all from me in How Well Do You Know Your Contracts. In the next episode, we will have Eileen and Wendy talking to you about third parties and remedies in undue influence.
The next element we'll be discussing would be undue influence in regards to the third party. We'll begin with common law. A case involving third party and undue influence would be rendered voidable. Seen in this case, actual undue influence had been committed by a third party. The contract would be voidable if the contracting party seeking to enforce this contract had knowledge or notice of this undue influence acted by the third party, or if the third party committing this undue influence was acting as an agent on behalf of that particular contracting party. When talking about presumed undue influence, it's very similar to actual undue influence, where for a contract to be rendered voidable, the contracting party seeking to enforce the contract had to have knowledge or notice that the third party was committing this undue influence, or if the third party was acting as an agent on behalf of the contracting party seeking to enforce the contract. Notice can come in the form of actual notice or constructive notice. Constructive notice is when the courts deem that the contracting party seeking to enforce the contract had known of the undue influence even though they did not have actual notice, as seen in the case of Barclays and O'Brien.
Under the Malaysian law, as mentioned in this case, Malaysian law does not have any specific provision that specifically addresses the issue on undue influence and third parties. However, Section 3 of Civil Law 1956 stated that the Malaysian law shall apply the common law and the rules of equity as administered in England. Furthermore, a case is unenforceable if a third party has exerted undue influence, and a third party cannot raise the issue on undue influence. As said by Zakaria Yatin J in this case, cases regarding third parties could not be based on common law, as it is inconsistent with Section 16 of Contracts Act 1950.
So now we'll begin with our comparison. Husband and wife under presumed undue influence is not under the category of special relationship
for both Malaysian and English law.
In this case, the wife and the husband were both directors of the company, so the wife's plea had failed as she was aware of the terms of the guarantee she had signed.
In this case, the High Court observed that the right of the wife to set aside a transaction if the husband is acting as bank agent or the bank had actual or constructive notice of the undue influence.
The main comparison we'll be doing will be if a wider principle to include other persons than wife should be accepted. In this case, the extension of the wife's equity to set aside the security transaction against the bank to cohabitees given by the English court case of O'Brien's has not been accepted in Malaysian courts.
Furthermore, Gopal Sri Ram had mentioned that it would be quite wrong and indeed wholly out of place to decide a Malaysian cases solely by reference of English law.
So to summarize this point, Malaysian courts have yet to accept cases of undue influence when it comes to cohabitees.
Finally, we'll examine the remedies for undue influence under the Malaysian law and the English law. Under the English law, the only remedies for undue influence is rescission, and when rescission is ordered, the contract are set aside and the parties are put back to the original position before the contract was made. However, rescission will not be available if one of the bars to rescission present. There are 4 general bars to rescission. The first general bar to rescission will be affirmation. The parties with full knowledge of the undue influence and the right to rescind still intend to continue with the contract will not allow to sue for rescission. The second general bar to rescission would be if a third parties obtain good honestly through a previous contract, where the said good have been obtained through undue influence, then the third parties are entitled to keep the goods. The third general bar to rescission would be delay. which is the lapse of time between the knowledge of the vitiating factor and seeking to rescind, as seen in this case. However, the mere passage of time will not bar rescission if the donor is still subject to the influence, and as seen in this case. The fourth general bars to rescission would be where restoration to original or pre-contractual position condition is not possible. In this case, it is obvious that the party could not be restored to their original position as the son-in-law already sold the hotel business and wound down the company. Two example cases where rescission is allowed would be the case of TSB Bank and Camfield 1995 and Cheese and Thomas 1994. However, there might be situations where rescission is difficult, as seen in this case. It was held that agreement obtained through undue influence were set aside, even though the parties could not be restored to the original positions.
In Malaysian law, a contract under undue influence may be rendered voidable at the option of the victim. Section 20 of the Contracts Act 1950 mentions that the contract may be set aside either absolutely or by the terms and conditions the court seem just, as seen in this case. If the party chooses to rescind, effects of the rescission may be provided in Section 65, 66, 67 of the Contracts Act 1950.
In comparison, for the remedies for undue influence under the Malaysian law and the English law, it is apparent that rescission is the only remedies provided for both of the legal system.
Damages are also not available in Malaysian law or English law. However, as seen in the case of Hadley, Byrne and Heller, if a bank breaks its duty of care, damages may be available for under negligence.
The doctrine of undue influence is equitable in the sense that it operates to release parties from contract they enter into as a result from being unlawfully influenced by other parties, whether intentionally or not.
Because the courts see the significance to make sure that common law does not restrict parties from redress, hence why discretion is exercised by the judge.
Hi! Now that we've completed a discussion on undue influence in both Malaysian law and common law, I think it's safe to say that we've learned quite a bit.
Yeah, we did.
To summarize, in common law, for undue influence to be a vitiating factor, it would mean that we had to establish whether it's actual undue influence or presumed undue influence. Under actual undue influence, there has to be some sort of unconscionable transaction, some sort of pressure exerted on the victim. In presumed undue influence, it's really similar. However, there's a difference where the defendant can rebut the presumed undue influence. Lastly, we've also discussed third parties' undue influence and how the criteria apply on whether or not a transaction will be unenforceable. And we also discussed remedies, whether the victim would want to affirm or rescind the contract.
In Malaysian law, undue influence is not separated as in common law. Instead, it regulated by Section 16 of the Contracts Act and described three different areas of contractual relationship. In order to prove undue influence, it must be presented before the court that the nature of the transactions calls for an explanation and that it is unconscionable. The defendant then has the burden to prove otherwise. Relief accorded to the contracts are similar to that in the common law, where rescission is the only remedies available.
In concluding, this journal study tells us that the doctrine of undue influence limits what amounts to legitimate persuasion, and that is why during a court trial, judges have to actively seek out the difference between legitimate persuasion and when persuasion becomes undue. The reason this is done is to protect the claimant from being unfairly disadvantaged, because when there is an imbalance of power between parties in a contract, that means that the claimant would lose autonomy over the terms or over the execution of this contract. Because undue influence is an equitable doctrine, not only will the claimant be allowed to make their case as to why there was undue influence in a transaction, but defendants too are allowed to rebut or disprove the burden that is placed onto them. These are the reasons as to how a contract can be vitiated under the doctrine of undue influence.